After a divorce mediation, do you have 30 days to change your mind? I'm Tulsa attorney James Wirth, and that is the question that we received. Somebody just asking, hey, after mediation, isn't it true you have 30 days to change your mind? And the answer to that is no, with a part exception. So there's no straight and simple rule like that. Mediation is voluntary unless it's court ordered, but even then, any kind of negotiations in ultimately coming to a settlement, it is voluntary. It's not arbitration where you've got an arbiter that's going to decide things. You have a mediator that's just helping the parties kind of come to a resolution, looking for creative settlements that may meet the needs of both, or helping the people come to the middle so that they can reach some common ground and agree on something. But it requires an agreement of both parties. It is not forced. And once you get that agreement, most of the time you're going to want to have it drafted up in some form and signed at mediation in case parties change their mind. It may not be enforceable if it's signed at that time. So that's best practice, what we want to do with all of our clients. If we reach an agreement, hey, draft it up, sign it so we can enforce it against the other side once it is agreed by the parties. Okay, after that point, do you have any kind of set time frame where you can change your mind? No. If an agreement is reached, it's signed by both parties, effectively that's a contract for a settlement of a case, and the courts will enforce that, absent extraordinary circumstances. Now, I said there's an exception or some caveat. In the law, we can always find some caveat. If you have a mediation agreement that says you have a set amount of time where you can, change your mind on this. So you can have an agreement on everything, have it'll draft it up, and in that final line, you have an agreement that if either party, both parties want an opportunity to, ponder this and verify it, and either party can cancel this agreement if they do so within 30 days. If that's part of the mediation agreement, then obviously that would be a basis. But otherwise, I've never heard anything about 30 days or any particular amount of time. I've never heard of anybody putting that caveat in a mediation agreement, but you could. But if you're dealing with this circumstance where you've gone to mediation and maybe you don't want to go along with that agreement anymore, or the other side is reneging on that agreement, you want to know what to do to enforce it, you're going to want to talk to an attorney privately and confidentially about your specific legal circumstances. To do that with my office, give us a call. Go online to makelaweasy.com.